Iran, 1979. Demonstrators invaded the American embassy in Tehran. Demanding the return of the Shah, they took embassy personnel as hostages in violation of international law. Treaty signed by the United States and Iran state that both countries will observe the principle of diplomatic immunity, a principle which protects foreign representatives and embassy property. All appeals to free the hostages were denied by the government of Iran. The refusal constituted an unprecedented breach of the rules of normal diplomatic behavior. Societies, nations, have always formulated laws to maintain order, to prevent anarchy and chaos. In similar fashion, nations have created international laws, among them rules providing for safety of their diplomatic missions abroad. Diplomatic immunity is a widely accepted principle. It assures protection for embassy personnel, even when the sending and receiving nations do not enjoy friendly relations. A violation of international law is extremely rare. The taking of American diplomatic representatives as hostages by Iranian students with the acquiescence of the Iranian government is a situation to be examined for the meaning it has for the rest of the world. From the beginning of the crisis, the United States has reacted with restraint, despite the outrage against its representatives abroad. Speaking from the White House, President Jimmy Carter.
The actions of Iran have shocked the civilized world. For a government to applaud mob violence and terrorism, for a government actually to support and in effect participate in the taking and the holding of hostages is unprecedented in human history. This violates not only the most fundamental precepts of international law, but the common ethical and religious heritage of humanity. There is no recognized religious faith on earth which condones kidnapping. There is no recognized religious faith on earth which condones blackmail. There is certainly no religious faith on earth which condones the sustained abuse of innocent people. We are deeply concerned about the inhuman and degrading conditions imposed on the hostages. From every corner of the world, nations and people have voiced their strong revulsion and condemnation of Iran and have joined us in calling for the release of the hostages. Last night, a statement of support was released and was issued by the President of the United Nations General Assembly, the Security Council, on behalf of all its members. We expect a further Security Council meeting on Saturday night at which more firm and official action may be taken to help in retaining and obtaining the release of the American hostages.
At the Security Council, the statement of Ambassador Donald McHenry, U.S. delegate to the United Nations, was moderate but firm.
There is in the United States a unity of purpose, a disciplined sensitivity to the needs of peace, a determination to search out for a peaceful means to bring this dispute to a just conclusion, and also a determination to do what must be done to protect our fellow citizens and the rule of law. That unity of purpose is shared by all Americans. Mr. President, the hostages must be freed.
From the beginning of the debate, there was an impressive display of unanimity among the delegates, reflecting opinions throughout the world. The delegate from Mauritius, Ambassador Rada Rampul.
Flagrant violations of international laws, conventions and treaties, and diplomatic practice, dating from times immemorial, cannot, must not, will not be tolerated by the international community.
Legal and political considerations.
While supporting the United States in its demand for release of the hostages, delegates were deeply concerned with the conduct of international affairs, the need to protect diplomatic status. The delegate from the Federal Republic of Germany, Ambassador Rüdiger von Weckmar,
joins.
The inviolability of members of diplomatic missions is indispensable for peaceful communication among nations. This is a long-standing principle which has stood the test of time and which is respected by all states regardless of cultural traditions, religion, or ideology. This principle of international law is embodied notably in the Vienna Convention on Diplomatic Relations, which Iran, too, has ratified.
The delegate from Japan, Ambassador Masahiro Nisaburi.
In addition to the humanitarian considerations, the present situation, regardless of the reasons involved, constitutes a deviation from the well-established norms of international law concerning the inviolability of diplomatic personnel and property.
Dr. Sergio Palacio Davizio, the delegate from Bolivia, spoke for the entire Latin American group.
The Latin American group reiterates its firm support for the standards of international law that guarantee the inviolability of diplomatic personnel and premises, as well as respect and protection for diplomatic agents.
The sanctity of the diplomatic envoy, not because his life and safety are of greater value than that of his fellow human beings, but because his protection of his person is an essential prerequisite for the conduct of international life, resides in a long tradition. It would be both sad and dangerous if this tradition were to be broken. My government has already conveyed this view to the appropriate authorities in Tehran. In doing so, we are acting on two premises. First of all, because we believe that the respect of international law, and in this particular case of the Vienna Convention, is an absolute necessity if we want to preserve international order.
The preservation of international order, a tradition that might be broken. The tradition has its basis in history and in the customary laws of Western and Islamic peoples. Also, specific laws have been agreed upon in treaties signed by the nations of the world. Louis G. Fields, Jr., legal advisor to the U.S. State Department, is a lecturer and writer on international law.
The basic convention that applies in the situation in Iran and the takeover of the American embassy and holding of its members of its mission staff hostage is, of course, the Vienna Convention on Diplomatic Relations. It was a convention which was promulgated in 1961 for the codification of customary international law in the field of diplomatic immunity and the regulation of diplomatic commerce amongst nations. And I think it's important to note that the first line of the preamble, which was adopted by the convention itself, says that the people, the planners, or the developers of this convention recall that peoples of all nations from ancient times have recognized the status of diplomatic agents. Now, this is a principle, a fundamental principle of international law that has its antecedents back to the first recorded period in civilized history. When one nation would send emissaries to another nation to conduct a diplomatic dialogue, to establish treaties, to regulate commerce, to do a variety of things, these emissaries were sent from one sovereign to another, received and protected while he is under the jurisdiction of the receiving sovereign. This has biblical antecedents. It comes into the Greek city-states who sent emissaries, up through Roman law, all through the period of history, recorded history. There has been this sanctity, if you will, of the diplomatic premise and the diplomatic mission and its people. As to the specific articles, I'd like to refer to three which are primarily involved. The first is Article 22 of the Vienna Convention, which holds that the diplomatic premises shall be inviolable. Let me read specifically from Article 22, which states, "The premises of the mission shall be inviolable. The agents of the receiving state may not enter them except with the consent of the head of the mission. The receiving state is under a special duty to take all appropriate steps to protect the mission against any intrusion or damage and to prevent any disturbance of the peace of the mission or impairment of its dignity." This means that the physical premises under which our mission functions is immune from anyone in the host nation from penetrating that mission. It is not extraterritorial as historically many embassies were regarded, but rather it is inviolable, free of any penetration by officials or persons in the host state. Obviously, the premises themselves have been penetrated by persons, perhaps with the consent and encouragement of the government, and therefore they have certainly breached the obligation of Article 22. The government of Iran, also under that article, had a special duty to prevent this. So even if you assume that the students have entered the embassy proper and taken it over without the consent or the official sanction of the government, that government owed a very special duty to protect those premises, and that duty has been neglected, indeed ignored. Now, when you talk in terms of the individuals, the members of the diplomatic staff, the so-called diplomatic agents, Article 29 says, "The person of a diplomatic agent shall be inviolable. He shall not be liable to any form of arrest or detention. The receiving state shall treat him with due respect and shall take all steps to prevent any attack upon his person, freedom, or dignity."
It is true that states have quarrels. They may disagree. They may have fierce disputes. In fact, they may even go to war. But even in that process, diplomatic immunity does not break down. If you could have an ambassador who could even go out and commit a crime, all that happens then is the receiving state tells his government, "Please remove this man. We cannot have him here." But the process of diplomatic protection obtains even in that clear case. So you cannot say, well, the ambassador has committed a crime, therefore his immunity is no longer obtained. That is not for the receiving state to say. Once this happens, the sending state decides or is told by the receiving state, "You have to remove this man because he's violated so-and-so, he's persona non grata, we don't want him here anymore." But the receiving state cannot take it upon itself and say, well, he's committed a crime, and therefore immunities which he would be otherwise entitled to have lapsed. This cannot happen. This is against the law.
The laws that protect diplomatic premises and diplomatic personnel are from time to time breached. But when breaches occur, they usually occur because of the illegal actions of mobs of private individuals, which are not sanctioned by the receiving state. In the very rare case where these breaches of international law occur either with the consent or with the abetment of the receiving state, then I think you face a quite serious challenge to the whole structure of international relations. And I say this because without the universally accepted principle of inviolability of diplomatic premises and the diplomatic agent, it would be impossible for countries to conduct normal relations with each other, to facilitate intercourse, to promote negotiations and the peaceful resolution of conflicts between them. So I would regard any breach of this particular law as a very serious challenge to the whole framework of the international society, and one which I would argue is contrary to the interests of all of us, because our diplomatic premises, our diplomatic agents can be the victim of such outrage.
Iran is an Islamic nation. Does Islamic law cover questions of diplomatic immunity? Dr. Majid Kaduri of the School of International Studies at Johns Hopkins University.
Yes, it does. Just as modern international law, the principles and practice of Muslim rulers was that diplomats, which they call them emissaries, used to be received, protected, and until they deliver their message, then they leave. And often they are taken to the border so that they be sure that they are in safety. They are thought of as being merely messengers. Whether they deliver a message agreeable or disagreeable to the ruler is immaterial. And so they were regarded as not liable to be tried. If they did violate the law or did anything harmful to the Muslim women, they are dismissed, but they are not to be hurt.
As the meetings of the Security Council continued, big power rivalries were put aside. Adherence to rules of international law were all important. The delegate from the USSR, Ambassador O.A. Troyanovsky.
Союз стоит за строгое соблюдение Венской конвенции о дипломатических сношениях.
We are for the strict compliance with the Vienna Convention on diplomatic relations. This position has been explained repeatedly by the Soviet delegation at the Security Council. Accordingly, the Soviet delegation, cooperating with the other members of the Council, has supported the statement of the President of the Security Council regarding the observance of the principles of immunity of the diplomatic staff and establishments, and the immediate release of the American diplomatic personnel detained in Iran. This position of ours remains one of principle and is immutable.
I venture to say the following. Firstly, the reaffirmation of the principle of the resolution of disputes by peaceful means and refraining from military threats or use of force in settling disputes among nations. Second, scrupulous respect for the principle of non-interference in domestic affairs of states and the observance of the territorial integrity of all nations. Third, scrupulous adherence to international law and to the rules that regulate diplomatic immunity. Fourth, a call for the immediate release of hostages on humanitarian as well as on legal grounds.
Mr. President, Iran is a party to the 1961 Vienna Convention. Consequently,
after extensive consultations and public meetings on what Secretary General Waldheim called the most serious threat to peace since the Cuban Missile Crisis, the Security Council met in a final session. The president of the council, Mr. Chen Chu of China.
It is my understanding that the Council is ready to proceed to the vote now on the draft resolution before it. There being no objection, it is so decided. I put to the vote the draft resolution contained in document S13677. The result of the vote is as follows. The draft resolution received 15 votes in favor and has been adopted unanimously. I now call upon the Secretary General.
Mr. President, in the past weeks, we have all recognized that we are dealing with a situation which is as unusual as it is dangerous. We have all recognized that the release of the hostages is of primary and urgent importance. We have also recognized that there are many other aspects of this problem which need to be seriously considered. The resolution which the Council has just unanimously adopted reflects the concern of the Council for the immediate demands of the situation, as well as for the points of view of the parties concerned. I earnestly hope that this unanimous decision of the Council will provide the basis on which we may proceed towards the peaceful solution which is unquestionably in the interests of all concerned.
The decision reached by the Security Council supporting the position of the United States was acknowledged by Ambassador McHenry.
Mr. President, the 15 members of the Security Council in their action today have given unanimous expression once more to their urgent call on the government of Iran for the immediate and unconditional release of the American embassy personnel being held hostage in our embassy in Tehran. They have called on the government of Iran to provide the hostages protection and to allow them to leave the country. It is clear from this vote and from the debate of the last 4 days, in which representatives from all parts of the world have participated, that the family of nations speaks with one voice in calling for the immediate release of the hostages. And we are deeply appreciative.
The Security Council debate would unquestionably have been of greater value if the Iranian government had followed through on its original decision to take part. Nevertheless, the meeting indicated the real value of the Council in contributing to a resolution of the hostage crisis. Also, the spirit of the debate was a reaffirmation of faith in international law as essential for conducting foreign affairs. The importance of international law is underscored by authorities in the field. Ambassador Ko of Singapore.
International laws serve the interests of all members of the international community, and if one has to differentiate between those whose interests it serves more than others, I would argue the contrary proposition, that international laws serve the interests of the small countries and therefore of the third world, even more than they serve the interests of the major countries. And the reason I would argue thus is quite obvious. The major countries can look after their interests even in the absence of international law. They can rely on their national strength, their economic and military strength. But countries like my own, which are small and which in realpolitik terms do not have very much power, can invoke the moral and legal force of laws to back our claims upon others and to resist unreasonable demands by bigger nations. So I would argue, therefore, that international laws tend to serve the interests of the third world even more than they serve the interests of the strong and mighty nations.
Most of the countries of the third world have signed the Charter of the United Nations. They have been admitted members of the United Nations and signed also other international agreements following the same procedure and the same methods as Western countries, whether Western or Eastern countries. They all regard themselves as being subject to international law. But we all know that international law is often needs effective sanctions. And effective sanctions have not yet been fully developed to enforce international law. So there are some states, they feel compelled by local domestic reason, domestic pressures, not to observe fully the rules of international law. Iran is one example.
Once small states, no matter how small, came into being, they had all of the rights and duties under international law, even as the biggest states. And here in the United Nations, we see this all the time, where small states, nowadays we're having states with population 100,000. And in the General Assembly, those states have the same voice as, say, a country like China, which has close to 1 billion people. So that basic principle of respect for the sovereign equality of states has been a principle that has benefited very small states so that they are able to express themselves, give vent to their views and positions in international affairs, and those positions and views have been respected. So in that general basic principle, it has protected them very well.
Let's take, in the political arena, the international laws which are enshrined in the Charter of the United Nations, forbidding aggression, forbidding intervention in the internal affairs of other countries, enjoining respect by all nation states of the sovereignty and territorial integrity of other nation states. These are three illustrations of international laws that protect the interests of the small nations of the third world. And to the extent that we are able to buttress these principles of international laws, they are a shield which protect us from the unreasonable and very often threatening conduct of bigger nations.
International law exists to protect rich and poor, developing and developed nations. Its rules are the threads in the fabric of world order. If this unravels, we have chaos. Without international law, no nation could act with any degree of certainty in carrying on affairs outside its borders. Large nations are determined to see international laws upheld. In a growing, interdependent world, smaller nations, not having resources to negotiate as effectively as the larger states, have an even greater stake in international law. The affair in Iran will be remembered primarily for the lesson to be learned, that, as there must be within nations a system of laws to maintain order, so must the world affirm and support an effective legal system for dealing with the conduct of nations. This is Paul Berry in Washington, D.C.